Hi everyone, and welcome to CADRIn Conversations, a video and podcast series in which we discuss aspects of alternative dispute resolution with regional and international experts. I'm Baria Ahmed, one of the co-founders of the Caribbean ADR Initiative, or CADRIn for short. We are a not-for-profit established to promote the wider use of alternative dispute resolution, or ADR, for civil and commercial disputes, other than the usual court litigation process. Today, I'm very pleased to be joined by the Honourable Barry Leon, a Canadian and the past presiding judge of the Commercial Court in the British Virgin Islands from 2015 to 2018. Now operating as an independent arbitrator and mediator, Barry is affiliated with Arbitration Place in Canada, 33 Bedford Row in London, and Caribbean Arbitrators in the BVI. He's also a member of the American Arbitration Association's National Roster of Arbitrators. A fellow of the Chartered Institute of Arbitrators and an International Mediation Institute certified mediator, Barry is the past chair of the Arbitration Committee of the Canadian Chamber of Commerce, ICC Canada. And prior to his judicial appointment, Barry was a partner and head of the International Arbitration Group at a leading international arbitration practice based in Canada. While his focus at the time was counsel work in arbitration, he served as an arbitrator and mediator as well. Until 2009, he was partner with a large law firm based in Toronto in its litigation and dispute resolution practice, and for many years served as the coordinator of that practice. Amongst Barry's many recognitions and memberships, he is a fellow of the International Academy of Trial Lawyers. Barry, welcome to CADRIn Conversations. Thank you so much for taking the time to join us today. How are you doing?
I'm doing well, Barry, and it's delighted to be here. I'm really pleased that you asked me to join you to talk about mediation. I think the work that CADRIn is doing is in raising the awareness of arbitration and mediation in the region, and the understanding of it is going to be very beneficial to the region, to people in the region, and to the efficient resolution of disputes. So I'm delighted to have been asked to join you today.
Thank you so much. And we're very, very happy that that we have the support of somebody such as yourself, and we're keen to have you engage with us and talk to us about your experience and what your thoughts are on regional development of ADR. So today, really, I wanted to talk to you about mediation, as you said, and in particular, how mediators add value to party negotiations. So starting by looking at that topic in the broadest sense, how do you, in your experience, mediators achieve this added value?
Well, let me start by saying, Baria, that the way I like to think of the role of a mediator is that the mediator is assisting in a negotiation. Mediation is really just assist negotiation. Parties can get together and try to resolve their dispute, or if they're trying to negotiate a business arrangement, to try to do that. But often the process isn't as efficient as they would like. They run into roadblocks, either in substance or because of personalities or because of the process. And so a mediator, in a broad way, just assists them in negotiation. That's the way I like to think about the role of mediator.
Right. So in the broadest way, as a negotiation expert, a mediator is helping the parties to engage in their negotiations in a more structured manner, and in a way where perhaps they have, this additional set of eyes and ears to think about, look at their problems in a slightly different way.
That's right, and I think that applies whether the parties are negotiating directly, that is, two business people or two individuals who are negotiating, and it also applies where they have lawyers, and it applies in a situation where the party is a business, a company, where there's more than one person involved. In all of those situations, a mediator with experience and skill and I think judgment can help the parties get through the roadblocks and do so in a more efficient manner than sometimes they can do on their own.
Yeah, yeah, absolutely. So focusing first then on the process, where would you say mediators employ their skills in enabling the parties and their representatives to get most out of the process of mediation?
So I look at it as mediators really have two broad areas, and you're right. One is helping the parties with the process, leaving aside the substance of what their dispute is or what their negotiation is about. It's just the process they're going through. The other, which we can talk about afterwards, is to assist them with the substance. That is to assess things that are relevant to the substance of the negotiation. So dealing with the process, when one thinks about what are the problems that can get in the way of negotiation, one obvious one is emotions. And particularly where there's been a dispute, particularly where there are parties with strong personalities, or sometimes parties with who have a history together. And so a mediator first can help with the emotional issues that can impede a negotiation, either that have been a problem up to that point or that are a problem as soon as they come in the room and sit down with the mediator. So there are a number of things that mediators can do, and indeed that all of us do in our daily lives. When you see two people who are in a situation where emotions are getting in the way, you try to calm the troubled waters in whatever way works in the particular situation.
Yeah, and I guess certainly in my experience as a mediator, where having this external person recognize and respect and respond to those emotions can be of real value, is where things have escalated to the point where those emotions have really become quite a block to the parties' communications.
I agree with that, and there's an expression that comes out of one of the famous negotiation books, and that's separating the people from the problem.
Yeah,
and that is so often the problem is the relationship between parties.
yeah,
And it's not just in personal situations, it's in business situations, between an employer and employee, between a supplier and the customer, between just all kinds of situations. And mediators use various techniques to try to get the waters calmed.
yeah. By allowing a space for those emotions to be expressed, by respecting those emotions and recognizing their importance, what you're offering as a mediator then is a cathartic release to the party so that they can then focus later on more substantive potential outcomes, potential options for resolving the issues.
I think you've hit one of the nails on the head, and that is to get people to recognize that there are these emotional barriers, and they are an impediment. And so sometimes it's a question of simply an acknowledgement that I understand that this has been difficult for you, that this has been a very difficult period in your life, and if you're the other party in the negotiation, and you really want to move the negotiation or the mediation along, you can contribute to that, or if you're the lawyer for that party, by also acknowledging, I understand, Baria, that this has been a difficult time for you, that the situation hasn't been easy. And sometimes you can almost hear the sigh of relief from that person when they get that acknowledgement.
Yeah, absolutely. And you picked up there on a slightly different but linked point, which is about keeping the discussions moving between the parties, and the communication that happens via the mediator quite often within the mediation process. Tell me a little bit about that. How does a mediator add value there?
Well, I think throughout the whole process, and we've been using one part of the process, is people will get bogged down, and the discussions start to go in circles on the same point. And while the parties could on their own say, well, why don't we move on to talk about this, or why don't we set this aside for now, the mediator can do that. So sometimes, to pick one example, the parties aren't making progress on one of 5 issues. Maybe just park that issue and move on to an issue where the parties will make some progress. Sometimes there's various other things that need to be done to keep the discussions moving, including later in the process to get one party or the other to actually put forward a proposal to resolve issues.
Yeah. Really what the mediator is doing is helping structure their discussions, helping to assess when certain aspects of the negotiations or the dispute need to be looked at quite closely, and perhaps also when they can be put to one side, parked, as you said, and reverted to later when it becomes more pertinent to be looking at that particular item.
So one other area that is related, and these are all, we're talking about them in somewhat discrete chunks. They're obviously a process and they're related. So part of what's necessary to have an effective negotiation and ultimately lead a deal is for both parties to have an opportunity to communicate and to feel that they've had that opportunity and to be heard. So if one party isn't getting that opportunity to speak, or even more importantly, isn't being understood or heard, because as we've all seen, people tend to listen to themselves and not listen to the other person as much as they should. So sometimes the mediator can intervene as in a simple way, just to ask the other side, well, what do you think about it? What's your reaction to that? What was your experience? Or sometimes can be by rephrasing or reframing what was said. So, Barry, what I understand that you're saying is such and such. Am I understanding correctly? And you're doing it in part for yourself as a mediator, but you're also doing it for the other party to the negotiation, or parties if there's more than 2 people in the negotiation.
Yeah, so the mediator is employing a number of different communication skills in not just ensuring that he or she has understood what the parties are saying to them or wanting to say to each other via them, but also to demonstrate that they're being listened to, that they're being heard, and that any communication that does take place via you as the mediator is clear and is respectful of what they wish for you to convey, subject of course to there being the occasion where they might want you to pass something which doesn't add value at that point in the conversation or communication.
And when that happens, I think one of the things that the mediator can be is a reality check.
Right.
So, Barry, do you think that's really going to help if I pass that along, or if you say that to the other party? Is that going to be helpful, do you think? Or sometimes you can even do it by role playing. So, Barry, you be me for a minute. And if you heard that, how would you react to it? And sometimes the penny drops, and I said, well, I wouldn't be happy. I would, or whatever the reaction it would be.
And that leads me to actually quite nicely, there are occasions where because of, and we can only sort of respect what the parties themselves have been through, having been involved in that dispute for however long they've been involved in it. But I imagine that there are occasions where you find quite difficult clients, you find quite challenging lawyers or attorneys. How do you deal with sort of tactics or negotiation dances that you might sort of get thrown at you as a mediator?
One of the things I like to do as a mediator before mediation is to have separate conversations, particularly where there's lawyers, a separate conversation with a lawyer on each side. And let's just stick with a two-party situation. And to just talk to the lawyer on the phone briefly, and both sides knowing that that's going to happen. And to find out what the lawyer thinks the difficulty has been or is in the negotiations that have taken place up to that point. Because usually there have been negotiations, or if there haven't, why haven't there been? And so sometimes you find out very interesting things. You'll find out that the lawyer says, look, I think you can help me because my client isn't taking on board my advice and isn't being realistic. And one of the things that you as a mediator could do, the lawyer would say to me, is help me convince her or him, or to demonstrate, to help her or him understand whatever the issue is. The other kind of thing that you can get is the lawyer will say, the problem I don't think is the party on the other side. The problem is the party's lawyer. And the lawyer isn't paying enough attention to this case, really doesn't understand it, hasn't focused on it, or the lawyer is a total jerk. It's a personality issue between lawyers sometimes. There's just all kinds of things. And then once the mediator has that information, she or he can work with that information in the mediation. And that's something that a mediator can do, but parties themselves really can't have those kinds of conversations, or it's very unusual that they would.
Yeah. And that's, it's the beauty of that neutral, independent third party who can perhaps say things in a manner which is more acceptable than if it was to come from the other side or their attorneys.
That's right. As a mediator, you come into the room, you've been chosen by the parties, which is often the case, or you've been appointed with the parties' consent, or chosen by somebody who's in a position of authority or trust. And so you come into the room, and most mediators are treated right from the outset with respect, with an appreciation for the fact that they're bringing value. So you immediately can do something that the parties often can't do for themselves, and that's to get the other side to listen to you. And even though you're a mediator, I think people, and you keep reminding people that you're not a decision maker, you're not there to do anything other than help them. They treat you as a person of some authority, and sometimes the mediator will have a background as a former judge, as a senior community leader, all kinds of things. But I don't think it matters. It can be a mediator with much less experience. That person coming into the room immediately, in most situations, commands their respect and will have the ear of the parties.
And how then do you deal with the difficult scenarios which we all come across in mediation? The tough post 4 p.m. People are getting frustrated. They are feeling like not enough has been done in terms of progress. How do you keep them going at that point?
I think you keep them going in almost any way you can. You try to read the situation. And, sometimes right from the beginning, you get somebody who comes in and folds their arms and they're not happy to be here. They've been told they have to be there, or if it's their lawyer has convinced them to be there, but they're obviously not happy. And then you get, as you say, by 4 o'clock in the afternoon, or sometimes by 11 in the morning, the parties are tired. Sometimes they're frustrated by the lack of progress. They may be angry with the other side. And I guess the ultimate problem is where one party is prepared to walk out. I've had enough of this. I'm leaving. I'm tired. They're not being responsive. They're not listening to us. They're not moving. And one of the things I try to do as a mediator is get a commitment right at the outset of the mediation, and I'll acknowledge that those things are going to happen. And when they do happen, it's going to be, you're going to feel angry, you're going to feel exhausted, you're going to feel like you want to leave. But can you agree with one thing, and that's that you won't actually walk out of the room without giving me a chance to talk to you privately and see if we can sort it out. And usually people at the beginning will go along with that, and then you can remind them of it when they're about to walk out of the room. Let's have a private conversation. And then you try to keep them there, keep them talking, keep the process moving.
And that's great, because what you're doing there is you are marking for them quite early on in the process the very realistic possibility that they will get frustrated at some point. So you can then hark back to that part of your introduction at the beginning of the day and say, if you recall, this is normal. Normalize their experience, normalize their reaction. And also that it can be overcome, and it is in most mediations overcome, as most mediations lead to a settlement. Great. Okay. So then, as you're moving through the process, you are obviously responsible for creating a sense of momentum and progress, so that the parties feel are less likely to get frustrated, not unlikely. So how do mediators help there?
Well, I think there are a number of things that mediators can do, but the objective is to keep the process moving. And usually there's always going to be some finite amount of time that people have set aside for the mediation, whether it's a half a day or a full day. And even if you know that you can go on past that, you need to keep the pressure on the parties. And I don't say that in a way that you're actually making them feel that they're pressured, but you want to keep it moving, keep the process moving. There's no point in going around in circles. And so you want to ultimately get to the point where people are exchanging ideas, exchanging proposals, and this will be after they've given thought to it. They've with your help, and we'll come to talk about this in the second aspect of where a mediator helps with substance. But after they've gone through the things that a mediator can help them with, or gone through it on their own, then it's to keep them moving, to keep them presenting proposals, responding to proposals, analyzing proposals they've received. And you want to make that happen efficiently by, if you've got a client and a party in a room, or sometimes two representatives of a company, and they're talking in circles, and they're not really doing what they should be doing, which is considering the other side's proposal or formulating their own proposal. And so you try to intervene and move it along.
Yeah, so there's what you're doing, probably you'll agree with me. I mean, certainly in my practice, is the first part of the day, and that there's no set limit or timeline to most mediations in terms of when things turn a corner. But the early part of the process is you as mediator trying to gather as much information as you can, and then there comes a point in which you do turn that corner and start encouraging the parties to share what information they're prepared to share, and sometimes encourage them to share information that up until now they haven't been prepared to share within the confidential framework that they're working in the mediation. So, and we will come to the substantive stuff that the mediator does in a moment, but let's just work through the process. So we've gone to the point where the parties have reached a level of frustration. We've talked them out of walking out. We've continued to ensure that there's a sense of momentum and progress. What about the latter part of the mediation? So let's assume a settlement is reached. What's the mediator doing in that part of the process to add that?
Barry, I think it's critical that people don't leave the room until they have, to use the business expression, papered the deal or written down the essential terms of their settlement or their. And I keep coming back, it's not just necessarily a settlement of a dispute, it could be a new contract, because I've been in those situations of helping parties negotiate a contract, but they've got all the important points, all the necessary points to legally have a contract written down, even if there's going to be a more formal contract later, or there's some minor points that need to be checked. And you want to have that one piece of paper, and ideally, where lawyers involved, they will come to the mediation with on their laptops the beginning of draft of an agreement. So they set out the basic things with blanks and so forth. It's likely there's going to be a payment of money. It will say X will pay to Y by such and such a date, such and such an amount, or it can all be reworked. But you want to have, whether it's handwritten or typed, something that parties, even if they're tired, will have down on paper and will put their name on, and that will be it. And you want to have enough energy and keep people focused to make sure that they don't miss any points. And one of the things along the way is to encourage the parties to be thinking about what are the things they need to have, want to have in a final settlement. So even if they're focused on what's the main payment amount going to be, there's a number of other things. So in an employment situation, a letter of reference, other things that will be part of the deal, and you want them to not wake up the next morning and say, oh, geez, I should have asked for such and such. You want them to have it all down on that, in that settlement agreement.
And you said, you rely quite heavily on the lawyers, if they are present, to lead really on the drafting of that document, perhaps bringing a draft with them that can then be added to. But as mediator, you are adding value in ensuring that the settlement is workable, that it's complete, that they have considered, points which may not have been part of the main negotiation process. For example, I find myself often asking, are there any tax points that need to go in here? For whatever reason, that hasn't either come up or it hasn't yet been discussed. So you continue to work with the parties, you continue to make sure that you're adding value as you progress. And what about the occasion where there isn't a settlement possible on the day?
Let me address that, but it just occurred to me as you were speaking, one of the things that we didn't mention at the beginning, and this is part of the process contribution, is that the mediator should make sure that where the party is a company, for example, the person coming to the mediation has the authority to settle. And it's a rude surprise when people go through a full day and get to the end, and the representative from one party says, I have to go back and get approval from my boss, from the president, from the board of directors. So those things, that's a process contribution that we should have mentioned early on. And then it obviously comes up again at the settlement stage, because even if the settlement needs to be ratified by a board of directors. Sometimes it does. That's, again, one of the things that needs to be set up and understood in the settlement agreement. Now, coming back to the question that you had asked about what happens if, well, people will talk about or they will say to the mediator, were you successful or were you unsuccessful? And it's a continuum in my view. It's not, I mean, sometimes it's a total failure, sometimes it's a total success, but sometimes the parties have made progress. They have moved along their negotiations. And so what you want to do as a mediator is encourage them, if they haven't come to a settlement, you push them as far as you can for that day, to say that the door is open, that your door is open if you want it to be as mediator, and to then show the parties that, you know, you have made progress on issues 1, 2, 3, and 4. I understand that you don't have a deal until everything's settled, but on number 5, why don't you go back and think about it, come up with new ideas, whatever it is. And so a mediation can be helpful to the parties, even if they don't end the day with a signed settlement agreement. And as mediators, sometimes you'll feel sufficiently invested in it that even if you're not hired to do this or asked to do that, you'll just contact both sides individually a week later, a month later, and say, you know, how's it going? Were you able to settle? Would it be helpful to you in any way? And so that's another thing that a mediator can do as part of the package of value that you try to bring as a mediator.
Yeah. So I think what you've said there is that there is, in just engaging in the mediation process, the parties may find that they have narrowed the issues, that perhaps actually where they started off, you know, with a list of claims and defenses on a number of points, that a few of those points have actually been addressed and agreed on, even if the whole hasn't. And that's a good basis for them to continue their conversations, whether with the mediator's assistance, and I think most of us are come with a level of perseverance to see whether we can carry on and get them there. But even if they want to continue on their own, you give them at the end of the day a summary of the progress that they have made, so that they can use that as a building block to continue their conversation. I
agree. I mean, that is an important contribution that a mediator can make to the process. So, in summary, of the areas in which a mediator can add value from a process point of view, there's been about 10 or 11 points that we've talked about. So one, which I mentioned at the end, is making sure that the people coming to negotiation have authority to settle, or understanding what their authority is. We talked about moderating emotions. We talked about keeping the discussions moving. We talked about to ensure that the parties are having an opportunity to communicate, that they're hearing and being heard, to help clarify misunderstandings, miscommunications, that where the lawyer has the client, the lawyer is having a problem with the client for the negotiation, or in the negotiation, you can help with that situation. Sometimes where the problem is the relationship between the lawyers, with a difficult lawyer or a lawyer on one side who isn't sufficiently engaged, you can help with that. Another process contribution we talked about is keeping the parties talking, the negotiation moving, even when you get to the point where one side might walk out of exhaustion or anger or anything else. And then we talked about keeping pressure on the process to keep it moving forward, so that people aren't going in circles. And then we talked about two things at the end of the negotiation, or the end of the mediation. One is where the parties have come to a deal, come to a settlement, come to a contract, and that is to make sure that all the essential terms are written down and it's signed. And then in the situation where they haven't settled, haven't come to an agreement, to try to help them keep the door open for future progress, either with the mediator's involvement or on their own. So those would be the areas in which I think, from a process point of view, a mediator can add real value to almost any negotiation that's having difficulty.
Mm-hmm. Great, thank you. And I think that's a great list, and you've captured that in really well in the summary. So let's move then to the substantive elements of the dispute, and we referred to this a little bit earlier. But in working with the parties' respective positions, their interests and needs, how do mediators work with these elements to help create and consider options?
So often in a dispute situation, the parties are focused on their legal positions. The lawyers are focused on their legal positions, who's right and who's wrong, or they're focused on often the amount of money. The claimant, the party who feels entitled to some monetary relief, is focused on getting that payment and has in mind a number that he or she wants to achieve, that may think is entitled to achieve. And so the first thing that a mediator can do is to get the parties focused on and assessing what their interests are, to help them think about what their interests are more clearly and more comprehensively. So often there are other interests that have not occurred to the parties, and even if they sat there and thought about it, the penny might not drop on that. So there's a question of hurt feelings. And not just in a personal relationship, but also in a business relationship. Somebody has been disappointed. I think one situation where the senior employee had badly let down the owner of the company, he felt very helpful and loyal to the employee, and so there were those emotional kind of interests. And so once the parties, you want to draw out from them what are the things that are of real interest. So maybe it's an apology or a recognition of what's happened. But sometimes there's other things. So if you're in a dispute situation that's leading to court or to an arbitration, the parties may have an interest in something that they can't get from a court or from an arbitrator. They can only be awarded certain things in terms of money or certain kinds of orders, but sometimes you can get a different kind of relief, or you can get something more creative in an ongoing relationship. Sometimes you can come up with a new business relationship. So the complaint is a defective product or something that didn't work the way it was supposed to. But at the end of the day, the parties may find that the best solution is, in both of their interests, a new kind of business relationship. So it's drawing out all of those things, or it's receiving money sooner rather than later. If the court process is going to take another 3 years, maybe the party will realize that taking less money now is more value. And if the situation is the party needs the money now because there's a child going off to university, they want to start a new business venture, there's just all kinds of things that parties might not be thinking about in terms of what their real interests are, and the media can help them, encourage them to draw out those interests.
Yeah, so the mediator is helping them sort of move away a little bit from what you described as the positions, the rights and wrongs, which can often be the focus, particularly as a dispute escalates through the courts or arbitration, and look instead at what would where the value might be in settlement. So whether it's having, as you said, some monies sooner rather than potentially later through the court or arbitration process, whether it's some form of continued business relationship which allows them to continue working productively, or their organizations, their companies to continue generating profits, etc. So so the mediator is adding value by really focusing them on interest, at least for a time, before they then look at settlement options, when I guess to a certain extent, their demands against the positions do come back up.
That's right. And you want to keep the parties remembering their interests as you go through the process, as they're assessing a proposal from the other side, or as they're formulating a proposal to the other side. Ideally a settlement agreement or any agreement out of a negotiation will have done as much as possible to satisfy the interests of both sides, and ideally in a way that expands the pie, that it's not just for every dollar I pay, you receive it. It's getting things that aren't costing me anything, or I don't care about, or you mentioned earlier the tax situation. Sometimes you can get a tax solution where the tax authority in effect is contributing to the settlement. Sometimes it can be some other type of contribution like that, where neither side is worse off. Both sides are either one is neutral, one is better off, and that's reflecting the interests.
Yeah. Good. Okay. And so, continuing then, what other elements in a similar vein does the mediator help them look at slightly differently?
So one of the things that comes up in almost any dispute situation is the mediator can help the parties realize the risks of the litigation process, the arbitration process. That it's an adjudicated process that somebody else is going to decide. And even with lawyers who understand the process, obviously, need to be reminded that things don't always go the way you want them to. And so I may believe that I'm right, and I may be right, but will the judge accept that? Can I establish that? Will my witnesses show up? Will my witnesses do a good job in telling the story, or will they fall apart? Will I fall apart as a witness when I testify? And it's not because I'm not telling the truth. It's because it's a process, and so there are those risks. There's the risk of delay in those processes. They take time. There can be appeals if it's a court process. So there's that kind of risk. And there's a risk because it takes time, of things happening that are going to cost money, or judge dies in the middle of the case, key witness dies, or key witness moves away and you can't get that person's evidence. We saw here in BVI, after the major hurricanes, documents were lost. There's just so many things that can happen. Those may be the extreme risks, but you ask me, what are the chances of the best possible case succeeding? And I would say it's certainly well below 100%, because there's things that can go wrong, and the mediator can help the parties appreciate those and keep reminding the parties of those things.
So there's no such thing as a sure thing when it comes to litigation.
Absolutely not.
I guess what you're offering in mediation is the parties taking back control, because they agree the terms that they are willing to settle on. Nobody is forcing them to accept an outcome in a as is the case in a judicial or an arbitration framework. Good. Okay. And then what about as part of looking at risks, as part of looking at alternatives? What about the impediments which might exist? How do you help parties overcome those?
Well, first you want to help the parties appreciate, and you as a mediator want to appreciate that there are impediments to a settlement, and it could be all kinds of things. The process issues that we mentioned before, the emotion. There may be regulatory impediments, but what you want to do is get those out, have the parties appreciate them, and so that they can design proposals and try to come up with a settlement that takes account or works around those impediments. Sometimes the impediment can be time, that just isn't enough time. So you work with that as a mediator. Mm-hmm. Sometimes it can be that a key person, decision maker, isn't available. We talked about that earlier when we were talking about the authority. So that may be an impediment that you would deal with. Those are more process impediments, but there are substantive impediments as well. Mm. Timing ones. So, for example, the settlement has to be approved by the board of directors. The board of directors can't meet or won't be meeting for another X months. You can keep coming up. There will be impediments, and the mediator can help come up with solutions to those substantive impediments as well as the process impediments.
Yeah, I mean, certainly in my experience, I've had occasions where parties have agreed a mediation, and it's become clear that actually they need to exchange more information before they can sit down at the mediation. It's not an impediment, but it's a prerequisite. For example, an expert's report, they need to see that from each other before they can really accept a basis for the negotiations. And that can mean that although they've agreed the mediation, they can't really engage in the conversations. And it may be that requires a decision around, shifting the date for the mediation until they have that information available.
Or it could be that the disclosure of document process isn't far enough along, so that the party's saying, I really can't settle until I see the key documents from the other side. Or it may be a personal injury situation where the injury hasn't gotten to the point where you know what the long-term situation is going to be. Yeah. Sometimes, as you say, that it means the mediation can't progress at that point in time, but sometimes there can be other ways around it. Mm-hmm. I had one case as counsel where, and at that point in Ontario, they had mandatory early mediation, so there hadn't been an exchange of documents. Right. But we agreed on a process to get out the key documents that you'd want to see, and that got over that impediment.
Right. Great. Okay. And what about sort of working with the parties on looking at possible options for an outcome?
Sorry, I missed. I missed what you had said, Baria.
Sorry, I was saying. So, and what about working with the parties in looking at the possible options for an outcome?
Well, I think what you want to do is, as a mediator or as a party, is to have a brainstorming aspect to what you're doing. Mm. So you've identified your interests, but then you want to just sit back and in a true brainstorming way. So let's just put all these ideas on a piece of paper, on a flip chart. There's no bad ideas. What are the possible things that could be done? As part of a settlement, get out all the options. Well, we could do such and such. but they're never going to agree to it. Well, don't worry about that. Let's just think about it. And is that a possible option? So that's creating the options, and then obviously evaluating them, because not every option is viable. Not every option is going to do the trick. But often the parties have gotten bogged down because they're not seeing options that are out there. And so the mediator's role can be to help in that process as well.
So you're engaging with them to be creative around the option generation phase of the mediation. And not, you do this, as you said, in private. So they're doing it, in confidence with you. It doesn't matter what the other party may or may not think about it. What you're encouraging them to do is to look at possibilities from the broadest possible framework. Great, okay. And what else? What else is the mediator doing from a substantive point of view?
Well, there's, I think some of the things we touched on broadly, but let me just break them down a little bit. So you had mentioned the parties need to appreciate the value of their own settlement, their own deal, and they need to appreciate all the reasons why having an agreed outcome now makes sense, so that they're not just focusing on who's right and who's wrong, and a court is going to, or I think a court's going to such and such down the line. But getting to take account of the legal costs of getting there, the stress costs, the lost productivity. They're not, whether they're away from work, whether they're a business owner, they're away from doing the things they should be doing. People in companies who are dealing with disputes are not doing their real job and are not doing things that are going to advance their careers. So all of those things, and then you also are trying to get people to for their enthusiasm for their own case, because by the time you get to mediation, often the parties have gotten to believe too strongly in their own case, from having lived with it, from having tried to, the lawyer trying to demonstrate to the client that he or she is in the client's corner. Because if both sides saw the case the same way, there'd be a settlement, because they both realize that I've got 47% chance of winning, the other side has 53% chance, and it was that clear. Obviously, never it's that clear. People always overestimate the strength of their case for legitimate or understandable reasons. So those are all things that the mediator can do as part of the substantive understanding of what they're dealing with. So once you've been through those and developed the options, then you're getting down to the brass tacks part of it, and that is the mediator helping the parties with the options to put together a proposal to the other side, a response to the other side that is realistic from the offerer's point of view, realistic in the sense that there's some possibility of the other side accepting it, a proposal that's consistent with their interests that we've talked about, with their goals, and with all of these other things, their attitude towards risk. The mediator is helping that formulate that. So then you've got the options boiled down to the leading contender or leading contenders, and that's what you're working with. And then the mediator, we're back to process now, is helping the parties exchange offers, assess offers, proposals from the other side, develop responses, and that's really down to the mediator bringing to the process ways to make so you're helping both sides. So I'm in the room with you, and I'm trying to help you put together the proposal that I think is the best proposal you can possibly put forward to the other side that satisfies your interests and your objectives, but at the same time stands the realistic possibility of being accepted or at least responded to constructively by the other side.
Mm-hmm. Yeah, and I guess the ultimate, goal for us as mediators is that all of that hard work pays off, all of those procedural steps and all of those substantive steps that we take to try and assist the parties and the settlement as possible, and that they can paper the deal, as you said earlier. What about the occasions where you have to do a little bit more, where you and there is there's a whole discussion around this about whether mediators should offer some additional support or evaluation as things get tricky in the latter stages of the mediation. How do you think mediators? Well, do you think mediators should do that, and how do you think they can add value in doing so?
Well, I think there's some situations where the parties have gotten to the point where they say, or want to say, well, what do you think? And if you're somebody, a mediator with substantive experience in an area, it's more likely to happen. If you're a former judge, then they want that perspective. And it's tricky, and there's the doctor's oath about do no harm.
Yeah.
So you don't want to. I don't think you should be offering a view to both sides without their consent and their desire that you do that. Mm-hmm. And for you to blurt out, I think such and such. Even if you have a pretty good understanding of where the negotiation is at, may not be helpful. But sometimes the parties want you to do that, and they may be stuck on an issue, and they may say, well, what do you think a judge is going to do with this? You've been a judge for X while, or you're experienced in the construction industry. What do you think? And if both sides want you to do that, sometimes you do that. Sometimes it helps break a logjam. It may not be on the whole case, it may be on one issue. Mm-hmm. And sometimes people just get bogged down and they just want a way out of it. So I'm not going to move from here. You're not going to move from there. I'd be happy to flip a coin. And there are those situations where flipping a coin may be the right answer. It's so small, but it's just a matter of pride or whatever. And if it's not flipping a coin, it's helping them come up with some more objective way to make the decision. Or it may be, and this gets into an area that is more controversial in some jurisdictions, where they'll say to the mediator, well, you decide. We've agreed on all the big points, but we're now stuck on one particular issue. It's the last issue. Neither of us really cares. Why don't you just decide it? Mm. And in some situations, that may be the right answer. If it's not to flip a coin, it's to say to the mediator, decide it. And now you would only do that as a mediator, obviously, where it's clear the parties consented, that's what they want. So whether you're doing it in a binding way, where they say they will abide by it, or whether you're just giving them a view, that can be a helpful thing to break the final logjam, the final point that's got people stuck. And there may be other ways to do it as well. As a mediator, you may say, well, we're fighting over, help them find some objective standard that they can go out to look to. obviously there are those issues where you won't have that ability, but there are some where you could say, well, let's check what's been done in these prior 10 situations. You're trying to establish the value of something, and yet there is data out there where it's been valuable. You should have been using that along the way, but if you haven't, the mediator may suggest that. So it's another way that the mediator can help the parties to get over that last hurdle.
So I think we're on the same page with this. What you're basically saying is that there is a lot of other ways. There are a lot of other ways, skills that the mediator utilizes to get the parties hopefully to a deal. But there are a few occasions where they require a little bit more. And it may be in the form of, the request may come in the form of asking, what you think might happen if they don't settle, given your expertise, given your background, possibly as a judge or a sector expert. Or it may be that they ask you to even make a decision so that they either overcome the hurdle on a single point or on the last little gap that exists between them, whether it's a flipping of the coin or something of that sort. Great. Well, I think you've given us a lot of information there, and our audience a lot of information there about the very many different ways in which mediators work with parties. I don't think we'll be under any any illusions about how hard mediators work. Was there anything else you wanted to add, just as a sort of final point in summary here?
I think that the thing that I would say to those people who haven't tried the process, try it. And in some jurisdictions, there's an old culture, particularly among senior lawyers, that the way you resolve disputes is you go to court, you have a trial, and a judge decides. But in this day and age, and I think even more so in what we've all been through with the global pandemic, there are a lot of situations where it's not just a question of right and wrong. It's solving the problem, getting a solution, getting a resolution, and moving on with your life, with your business. And so I just think that there are so many ways in which mediation can be useful, whether it's disputes between couple, whether it's disputes between businesses, whether it's disputes between countries.
Mm-hmm. Wonderful. Thank you so much, Barry. That's been a really informative discussion for me, and I'm sure for our audience as well. And we look forward to having you come back and talk to us more, perhaps about arbitration next time. But certainly, it's been wonderful to have you talking to us.
Thank you so much for inviting me and the opportunity to share my views with you and to have the discussion with you and with the listeners.